Do you have the court
list?
date?
Oh,
it's the same one you have. It's just when we tried to look at it, I couldn't read it because of color combinations. It was too dark.
January 6th, I believe it is. January 6th. I can look it up.
January 6th at 8:30. If you give him notice for that day, please, Corporal. And that brings us back to Mr. Pittman.
Oh, Mr. Pittman, come on in.
Mr. Pittman, good morning. Mr. Pittman, you're here back for first appearance again. Your cousin, Mr. Hudson's in the courtroom, sir. Mr. Pittman, the law enforcement, I held you yesterday because I didn't feel there was probable cause in that complaint for assault. They have since amended the charge, and they've now accused you of one count of culpable negligence. What that charge is, it's a misdemeanor offense, and they're basically saying, Mr. Pittman, that you're culpably negligent for taking your mother out of the facility she was in and putting her in an unsafe environment, an inability to take care of herself due to her medical or physical condition or mental health condition. That's what you're accused of. It's a misdemeanor offense. I have read this new complaint carefully. I actually went and pulled the culpable negligence statute to make sure I understood what the elements of the charge were. And there is, well, yesterday you wanted to represent yourself for first appearance purposes. Is that still the case, sir?
That is, Your Honor.
Mr. Pittman, anything you want to be heard on probable cause on the new charge of culpable negligence?
Yes, it is, Your Honor. Can I speak?
Before you say anything, let me give you this caveat. Mr. Pittman, we're being recorded. You're the defendant. Yes. If you talk about the charge itself, this recording could be played and used against you. So I would encourage you, do not talk about the charge itself, but if there's a legal argument you would like to make, I'm glad to listen, but I wouldn't talk about the allegations against you because you're the defendant and you've chosen to represent yourself at least up to this point. So is there anything you would like to tell me about probable cause or any legal argument you would like to make?
Well, I first would like to make a legal argument as far as an objection to these proceedings. Number one, I was never given my Miranda rights at any time. So I object on that ground first.
Mr. Pittman, Miranda only applies to in-custody interrogations. There's no evidence of any statements they're using against you or trying to use them against you. Therefore, Miranda doesn't apply unless they're trying to use statements against you. Had you accepted my suggestion that you get an attorney, you would know that, or your attorney would know that, but that's not a valid basis to object to anything unless they're trying to use statements against you, which they're not so far. Any other points you want to make?
Well, I anticipate that they will. So I've expressed that one objection. Okay. Objection number two. Objection number two is that my name is Randall Pittman. In 2003, I'm sorry, 2007, I became a private attorney general for the state of California.
Your Honor, I'm going to object to this. This has no bearing on probable cause for this fact matter.
Your Honor, I have a right to speak. I have a right to speak.
Mr. Pittman, you have the right to speak on probable cause, but that's what we're here for, is whether or not there's probable cause.
I have a right to make 3 objections. I'm just making 3 objections, and just let me do that, and then we can proceed. I'm a private attorney general of the state of California. I've been working undercover for them for about 20 years, and I am disclosing that information. So what that means is that this court has no jurisdiction over me because I'm a California.
Yeah, you're wasting our time. You're wasting our time. Even if you were a private attorney general, that has nothing to do with whether or not we have jurisdiction over you if you're accused of a crime. Mr. Mitchell, anything from the state regarding bond, sir?
Your Honor, we would just ask for a reasonable. Mr. Pittman, we would just ask for reasonable bond under this situation and absolutely no contact whatsoever with his mother, Willie Ruth Pittman.
Mr. Pittman, I'm going to set you the standard bond I would for just about any misdemeanor charge. That's $2,500 cash or surety. Mr. Hudson, I apologize. I didn't give you a chance to speak on Mr. Pittman's case. I know you have some things to add on her case. Anything you want to add on his case? So, Mr. Pittman, your bond is $2,500. It's the same set on just about every misdemeanor. It's cash or surety, Mr. Pittman. You'll use the phone in just a few minutes, sir. You post the bond, you'll be released. Mr. Pittman, 2 more things. Number 1, I'm going to ask the jail to give you a notice for your arraignment date, which will be
January 5th.
January 5th at 8:30. Secondly, Mr. Pittman, you do have that still condition of no contact with your mother for the reasons I put on the record yesterday, and even more so now that you've been accused of a crime directly relating to lack of providing care for her. So you've got a condition of no contact with your mother, at least temporarily. Mr. Pittman, do you have any questions, sir?
Yes, Your Honor.
Okay.
I have paid for a 24/7 caregiver for my mother who was at the house when I was arrested. I did not know she was being arrested. If I had known, I would have made sure that the caregiver would have taken over right then.
Mr. Pittman, Mr. Pittman, you're commenting on the case that you're accused of, and I've told you that's a bad idea. I'm going to stop you because you're going to hurt yourself is what you're going to do. You need to talk to an attorney, a real attorney. You need to talk to a real attorney, Mr. Pittman, that's licensed in Florida, is my suggestion.
By white society. I'm an African
Your first
American.
appearance is completed. I'm not going to try to talk over you any longer. Have a good day, sir.
Thank you.
Okay.
Come on. We'll talk to you soon, buddy.
So, Mr. McDaniel, is it Mr. Hudson or Dr. Hudson? Dr. Hudson is here. Mr. McDaniel, it's not on his case. He needs to be taken out of the first appearance room. Dr. Hudson, do you mind coming up, please?
Yeah.
I need them.
Judge, just a clarification, because you said that they amended it to this charge. Does that go away with the charge yesterday? The jail and me are both a little bit confused. Or is this a new charge on a new case number? Or?
Come on up, Dr. Hudson. So we'll clarify this first. Mr. Mitchell, what's the state's position on that?
I think from what we had with what I've had discussions with the investigator and the Smaggers, they amended the complaint for the yesterday's charge also and added this one in addition.
So it's going to go in the same case number?
No,
Yeah.
The complaint doesn't say amended anywhere.
Oh.
So it's going to have to be set up as a separate charge. I found probable cause. So we've got two complaints that's not amended. So he has two charges, one of which I found no probable cause. That's the assault with the ROR. The second charge is the one I found probable cause on. I've set the bond on today. So what y'all may dismiss that assault if you choose to, Mr. Mitchell, but because this is not an amended complaint, it's just a regular complaint. It's not amended. It doesn't say amended at all. So if that was their intent, they didn't do amended complaint. They just did a regular one. But either way, we can get to where we need to go and get in court. Don't do anything else.
Oh, did you say ROR on that charge from yesterday? That's what the jail's telling me you said.
No, I didn't set up. Oh, you're right. I found no probable cause, but he waived that.
Yes, sir.
And he gave
Thank you for
5,000
correcting
bond.
me. I said 5,000 on that. That was an assault, but the only reason I did that is because he was waiving that right. So, Mr. Mitchell, what's the state's position on that?
We could keep it as it is right now until probable cause is challenged. I mean, he's representing himself right now, and he waived that.
I'm not comfortable with that. I wanted to hold him, Mr. McDaniel, because I want to give the state time to get the complaint correct. I don't think that's really fair to him to set a $5,000 bond on that assault, given he waived probable cause because he was trying to get a bond set. He wasn't able to post the bond, obviously. So I'm going to change that $5,000 bond to an ROR on that case. I guess it's possible the state will go forward with an assault. It's hard for me to imagine them being able to do that on a conditional threat like that. And I fully thought they would amend that complaint, but they didn't. They just filed a separate complaint. So to make it clear and try to be extremely fair to him, he's got a ROR on the misdemeanor assault. Probable cause was found only by agreement, not by fact. And he's got the bond I set this morning. So he's got a total bond of $2,500 cash or surety to clarify. Thank you. So Mr. McDaniel, Mr. Mitchell, this is Dr. Hudson. Dr. Hudson was here this morning. My understanding from Dr. Hudson, talking to him real briefly about just to see what his role was. He is the nephew of Miss Pittman and the cousin of Mr. Pittman. But Mr. Hudson, Dr. Hudson came to be heard. He has some information on Miss Pittman. So Mr. McDaniel, I know that you're trying to get her out and find out where to go. So Dr. Hudson's here to give us an update on what efforts the family's been able to make thus far. Doc.
Okay, good morning. I'm the nephew of Miss Willie Ruth Pittman. My mom is her sister, but I'm also the cousin of Randall. We've been having issues, as this court knows, for a couple of years with him. and I don't want to seem negative, but taking advantage of her situation. As you can see, there's some mental issues with him as well, but she definitely has dementia and also mental health issues. It is hereditary. And so I've been trying to become her power of attorney. He has a power of attorney on her, as well as her health. And that's why he's able to do the things that he's been doing. We've had her in several facilities in Jackson County, and each time he goes and does something, either alienates the staff or just takes her out and takes her home. This time when he took her out, she was in Tallahassee where I live, in a facility. And we were trying to get her stabilized, and I had my lawyer to go meet with her to see if she would allow me to become the power of attorney. She agreed at first with me there, and then she wavered and didn't agree. And then I think he came to court, and because she was in the facility, they dismissed the previous charges against him. And so he was able to go and take her out. I've been trying to get him stabilized, to get him a job and everything. I even gave him a vehicle to get to work, and he turned around and used that to travel and get her out. And so I just had a question. Can his power of attorney be overwritten? And because of her mental state, could someone else, she has 2 other sons, but they're not in a mental capacity to be able to do it as well.
There's 2 ways to essentially in Florida, there's 2 ways to get rid of a power of attorney. One is if the person granting the power of attorney revokes that power of attorney. It's called a revocation. She has to be competent to do that, and she has to do that in writing, just like she would the power of attorney. The second way you can override a power of attorney is called a guardianship.
Okay.
A guardianship or an emergency guardianship is where someone would hire an attorney. The attorney would ask the judge to create an emergency temporary guardianship, and that guardianship would override the power of attorney. Typically, that's going to have to be accompanied by some type of medical documentation, doctor's notes, doctor's recommendations, something to support it. Sometimes it may also have to be accompanied with some reason. Normally, your children are your guardians, so you have to have a reason to say, Judge, in this case, if your position is this, the child or children are not appropriate guardians, and here's the reason. So that's the 2 ways, the 2 only ways I'm aware of in Florida to set aside a power of attorney, those 2 ways.
Okay. So would her other son, Randall's twin, be able to request a revocation of his power of attorney?
The revocation of a power of attorney is a simple form she signs. It's got to be appropriately notarized and witnessed.
Okay.
It's got to be prepared. And then what that does is that gives her no power of attorney, and then she needs a power of attorney, arguably. Right. So if she chose to issue another one, she could sign one and then immediately sign the next one, naming whoever the new power of attorney is, whoever that is, if she decides to do that. But she has to be competent to do both of those.
Well, what if she's not competent to
If she's not competent, then guardianship's your only option.
Guardianship. Okay. All right.
So as far as placement goes, it sounds like even if he has no contact, the power of attorney that's currently in effect is an issue or a roadblock in placement.
Yes.
Mr. McDaniels is trying to get her out. I would consider any type of release options to get her out. I just got to have a place for her to go.
Right.
Okay. Any additional information that you need, or any questions you have for the attorneys?
No, I'm just thank you guys for working with her. I know it's difficult, and specifically in her mental state, because even with me, she's kicked me out of the room at least 20 times. And so that's why it's sort of challenging to get her to see what's in the best interest of her.
Yes, sir. Mr. McDaniel, any suggestions or advice in her case of where you want to try to go from here? We kind of handcuffed until we get placement options, or what are your thoughts?
My thought is just like that text I sent. It's the sheriff's office duty to contact DCF when there's an elderly person that's in danger. DCF shows up at their office and interviews her and talks to her, and then tries to find placement with them. They completely skipped that step to basically bring her to the jail.
That's not what the complaint says. The complaint in his case, The complaint in her case goes in great detail about what efforts the sheriff's department made, Mr. McDaniel, to try to find alternative placements. And I don't know it's as easy as you're portraying it. According to that complaint, they went to a lot of effort to try to find a place other than jail, and they didn't have anywhere, is what I'm reading.
I read it as that they were calling the non-emergency number, and they were not. I mean, but if a person is just like a minor child is in danger, they'll take them to their office and they hold them there and they'll call the emergency number, not the non-emergency number report. They said the complaint that they reported it to DCF, but when you're sitting in their office, they'll have someone call them on the phone and talk to them and say, we've got this person here that needs assistance, and and they'll come out there. I did not see that happen. They brought her straight to the jail, and they did non-emergency calls. I agree with that, but they didn't do the emergency call, just like you would with any minor that gets arrested.
I think you're second guessing them, and I just don't know that's fair given the complexity of the situation. But I'm willing to release her to any reasonable location immediately. Just got to have somewhere to let her go. Let me see if Mr. Mitchell, anything from your perspective?
No, Your Honor, we're in agreement that she needs a better placement once some placement has been found.
So, Dr. Hudson, she hasn't been determined to be incompetent. Let me put it that way. I'm not saying she's competent. I'm just saying she hasn't been determined to be incompetent. So if she either agrees to go somewhere voluntarily, live with a family member or a friend that's going to take care of her and it's a safe environment, or if there's another way, such as a guardianship or a valid power of attorney to get her somewhere, I would certainly consider that. I'll get Mr. Mitchell's input, Mr. McDaniel's input. But I can't just say, put her out of jail send her out the front door.
Right.
Can't do that.
Yes.
In good conscience.
I understand. And it's probably safer to be there than to be out on the streets anyway. So, because there's not a family member that can control her and to be there 24 hours a day.
Well, thank you for coming, Doc. And if you get any additional information, please pass it along to Mr. McDaniel, and then he'll pass it along to the rest of us.
And I do know the sheriff's office was trying. They said it may be a place in Ponce de Leon that she may be able to go. So I'm going to call her again today from the sheriff's office to see if.
Who is that contact person that you were talking to there?
Probably Investigator Willis Hodges.
Peggy Hodges.
Yeah, Investigator Hodges.
Yes.
Yeah, I know that she's been working on this case a lot. She called me. They made the first arrest with warrant questions, and I explained you don't have to have a warrant. At that time, it was spitting on an officer, I think is what he was accused of, and she was accused of spitting on an officer. So there was no warrant because it was officer. The felony allegedly occurred in the officer's presence, but I don't think they were wanting to charge her. They were looking for other options. They just didn't have any.
Well, they didn't know, and they've been experiencing that as we have as well, because she does the same thing to us and throw things and different things like that. That's why we're trying to find a facility that can manage that.
Well, if there's a way to get her to a facility, I said her a low bond, but I would even consider something else to get her out if we get that option.
Okay.
Thank you for coming.
I'll work on that.
Thank you, sir.
And I contacted
you, guys.
DCF, and they're not going to do anything if she's in jail. I mean, they're not even going to come interview or anything. So I still think that the solution is the sheriff's office has to wait till the DCF shows up.
So,
and
Mr.
they
McDaniel,
won't come out here.
Mr. McDaniel, if I were to release her, I can't release her to DCF custody because they haven't accepted custody of her. There's no court order, right?
Correct. I mean, no. If there was no criminal charges and the sheriff's office had no place for her to go, and she was an elderly person like that, they would call and they would have to wait until DCF shows up.
I don't know. You think your impression is if you have an elderly person and the sheriff's department's involved, let's just take the criminal case out of this equation for a moment. There's an elderly person and there's no one to care for them, that DCF will accept responsibility and find a placement for them. That's your understanding of the law?
Correct. That's my understanding. I'll try to find. I don't know case law on it, but I mean that's what they're there for, is to help minors and elderly and
I don't know. The Department of Children and Families, I don't know if they have the ability or the mandate to find placement for individuals. If that were true, we wouldn't have a homeless crisis. I just don't know that that's accurate, Mr. McDaniel.
Yes, sir.
I don't know. I've never seen it. I mean, we've got a lot of people that need placement.
Correct. It is, and it goes to where if they're in danger, now if they're not in danger and if they're not incompetent and they're, that's what a lot of the ones that you see are homeless a lot. Yeah, they're not in danger, they're not incompetent, but if someone that's can't walk and is bedridden, that's, in hospice care, I mean, that's a little bit different.
Okay.
And, I think that's a little bit different on that scenario. And I think that they would have to come in and try to find some place to, normally what they would do is try to talk to family members. And I'll be honest with you, they will twist arms, family members, to try to get them to take them. That's how they would handle most of those situations. But when everything else, they can't do anything, they would have to be responsible to find some place to take her, which may be a hospital, and let her sit there at the hospital, until they can find something.
And I think in this case, she was in the hospital and then she was released from the hospital and that's when all this happened, right?
Yes, sir.
Okay. Well, thank you. Thank you, Mr. McDaniel, for trying to find her a place, Mr. Mitchell. And thank you, Dr. Hudson, for coming today.
Thank you.
Okay, thank you, sir. All right, so Mr. McDaniel, that's everything I had on my first appearance list this morning. Have I missed anything, sir?
No, Your Honor.